Good evening. This is the regularly scheduled meeting of the Warren Planning Board. We have a roll call. If we could start with you, Jenny.
Jenny Flanagan. Terry Delapaz.
Tyler Dixon.
Fred Massey.
Jim Leffers.
Ashley Medeiros and Mike Gerhard are both excused absences. And Rick Matson, I understand, is our alternate, is indisposed. So those three folks won't be here today. Before we start, the application for 10 Liberty Street will not be heard tonight. That was a decision that was made by the applicant and the opposition. So apparently that will not be heard tonight, and we will be moving that to the main meeting.
Mr. Chair, just to formalize it, I would read out exactly what's on the agenda, number 4 applications, 10 Liberty Street, et cetera. Now for
Okay.
motion to formally continue to next month.
Okay, 10 Liberty Street Partners LLC, master preliminary plan, 20-unit owner-occupied condominium housing development, including 5 affordable units. It was continued from March 25th due to the court order. Subject to continuing judicial matters, the applicant may need to be continued again or stayed due to possible appeal of the master plan decision. So,
Motion to continue that agenda item.
okay, and I'll make a motion to continue that agenda item to the next meeting in May. I believe it's the 20th. 20th. So I'll make that motion a second.
Second.
Jenny, all in favor?
Aye.
Aye. Okay.
And Mr. Chairman, just so everybody understands, May 20th is the meeting, not the 27th, because of the Memorial Day holiday. So just
Okay.
want to make sure that's known for the record.
Great.
So the approval of the minutes for 325. Are there any, I know that Mike was concerned that they were rather long, the minutes. We had talked about shrinking them down somewhat. I thought they were an accurate representation. My only concern about them is that if we put in every comment made by a member of the public, that they could get pretty long in in any given matter.
Obviously, Haley's not here this evening due to a prior engagement from that standpoint with her doing the minutes, but she does do the minutes accordingly, the way that, I don't want to be rude, but the way she sees fit. It's upon you folks to offer suggestion, change, or what have you to how the minutes are taken. I know from the past, the prior recorder, I believe, what took much more intense, lengthy notes, and that you asked that to be paired a little bit. And I think that's where Haley picked up on that. So if there are additional methods or things that you would like to see or not see, I would at least just state that for the record, and then she can try to accommodate you.
Well, first and foremost, I would say she's doing an absolutely outstanding job with them. And I was communicating Mike's concerns, not my own. There may be an opportunity for us to chat, given another matter that might be a lot more lengthy, because I do think people can go to the tapes if they want to hear everything that went on. So it's a balance between what is necessary to put into the minutes, particularly in terms of decision-making or, legal recourse after the meeting.
And we are entertaining more development applications, and I have to consult with Ben, but essentially I'm inclined to start thinking that when we do have a public hearing on development applications, we should have the court reporter in here, just like they do with the zoning board.
That issue has come up in the past, and I think with the former town manager, the board did get approval, particularly with those very intensive applications, so we have an accurate record, but certainly that's.
Yeah, so why don't we'll consult with Haley.
Yeah.
I mean, again, she's done a very professional job and this is in no way a reflection of the fact that of her work. It's really just, I can see what's coming down the line and every individual who has something to say in the meeting, if she's responsible for recording that, I just don't think it's fair to her, frankly. That's my biggest concern, and it's just a lot of extra work. Other than that, I had no question about the minutes, 3/25, 2024. Does anyone have any revisions that they wanted to make or comments? If not, I'll make a motion to accept those minutes.
I'll second.
Second, Jenny, all in favor? Aye.
Aye. Aye.
Okay. So we're moving on to the comprehensive plan. Couple points here. The planning board met with the town council regarding the comprehensive plan. The council almost unanimously thanked us for the work that had been done on the plan. I think that there was an appreciation from most of the council members as to the amount of work that had been done on the plan. And a number of them had obviously read it very carefully. And so I feel confident that what we're looking at here is a pretty, is a good, successful draft. And I think the word draft is important here because we're still open to comments. The comprehensive plan went through public comment for every element, and we will have yet another public meeting with the entire comprehensive plan, most likely in June. The edits that we're talking about, you all received them. One of the most important ones to me were the ones that Herb put together regarding affordable housing. They are detailed and to me are strengthen the position of the town in terms of our ability to fend off unwieldy state demands. This is a balancing act we're working on here, trying to find the kind of protections that we can put in place that will stand up to some of the legislation that's been passed relative to what is called affordable housing, but which in fact is more about unbridled development. And I think I know that Herb's edits speak to this very specifically. We had addressed this in the comprehensive plan, but in light of the new legislation that appears to be moving affordable housing from 25 to 15% of the total, it was bad enough at 25%. It's completely unacceptable at 15%. So that particular element, Herb has given it to Allison, and Allison will massage it into the format for statewide, for the comprehensive plan. So are there any concerns, comments about that particular edit?
So I'm coming at this very late because I'm new to the board. And kudos for everything the board has done. The question I have is about inclusionary zoning and whether that's a tool that we could use. As I understand it, anytime anyone proposes to put in more than 4 dwelling units, they must provide affordable housing. And I think South Kingstown has that. I think North Kingstown has that. I don't know whether that was considered or not.
I know the community has talked about the inclusionary zoning enabling legislation before. I know that with the So it still could be on the table with regard to the discussions for us when we get into the update to our land use regulations. The one thing too that plays into that is that with the amendments to the comprehensive permit, where there's density granted by right and that sort of thing, that it really overshadows the inclusionary zoning, because technically you get more, a greater percentage of units that are affordable under the comprehensive permit than the inclusionary zoning. But it's not to say that, you know, that's a different alternative that can be looked at. So it's not off the table. Right now, we've just been focused on generally what's been enabled and getting this plan through so that we can jump into the what I'm used to calling bylaws, but the land use regulation update.
So would, based on Jenny's concern, is that something we want to include in terms of noting inclusionary zoning in your edits?
I mean,
Or do,
can I say something?
no, I mean, I just wanted to answer
Yeah.
that question first.
Sure.
Should just leave the mic on at this point. So the, I have to check to see, to remind myself if it's in here or not, but I think if it's something that you're particularly interested in, just, I would say for the record, to have Allison weave into the goals or part of the action steps to consider inclusionary zoning when we're looking at the update to the land use regulations, including zoning and subdivision.
Okay.
And if, you know, sort of saying that, just, you know, if you
So-
agree with that, just say it
Alright.
into the mic.
So you're saying like inclusionary zoning, that would be the scenario where any new development over certain density requires deed restricted affordable housing as part of the program.
A certain number of units, yes. I don't have the
So-
enabling legislation on the top of my head, but 10%.
For instance, if someone came in to do a mill rehab projects, they couldn't do it all as market rate units. A certain percentage would have to be included as affordable by mandate, even if.
I would not at all support that.
Okay,
So it's we're just checking the law. It's 10, just so you know, it's 10% of the total units proposed. And there's no minimum number that you have to put on the table.
So, let me get this. So any development,
Anyone, that's the thing.
any
Like,
development would be
and you can build
subject,
over a certain threshold. And I
Over
think
a
it's
certain
something, it's
threshold
10,
of
it's
what?
10 units.
of number of units?
Yeah, if the project is 10 or more units, and at least 10% of those units has to be affordable.
But our statute, there's no minimum number. So it's any number of units that's proposed, 10% of that needs to be affordable.
Yeah,
I
I
think
mean, I
that
could
it's
see
like,
that view.
yeah, I don't think that would happen. I
It
mean,
has to match I'm assuming that at least the exterior has to match the look, just like in a comprehensive permit.
Right.
You
Yeah.
can't be able to tell.
No, but I mean, I think if we're talking about 10 units, anything over 10 units, is that?
It's not, it doesn't say a number exactly.
Well, but if
10%.
it's 10%, it's not gonna apply if it's less than 10 units
Yeah.
anyway.
Because you're getting your 1 unit there.
Yeah.
That's what she said.
Right.
By default. Like,
Will it round up though?
But that's not, for example, like Tourister.
Right. Forrester would have had to have,
Tourister would have had a certain number of affordable units within it. Fairly significant number.
Right.
I
and,
forget how
and,
many.
and it doesn't necessarily move the needle, but it doesn't move the needle backwards.
except that it does from a developmental standpoint. When you alter the ability of a developer to structure a deal, a transaction that is based upon the economics in the marketplace, then you restrict a natural form of development for the economics of the community.
And that may be the case, yet they've been able to very successfully develop in South Kingstown for 25 years using this as a requirement. Every development in South Kingstown in the past 25 years has had inclusionary applied to it if it's more than 10 units.
Yeah, I'm not saying that there's not a market that is such that it could sustain that, But I would say that there's a lot of markets that are outperforming South Kingstown simply because they don't have that kind of restriction on it. You know, I'm not saying necessarily Rhode Island, but I just know that that is, you know, the economics of it. It's just like simple math to know.
Right,
how-
and I'm just responding to
And the other- the other-
general comment. of,
Right, no, I
Let's
understand.
move the needle.
Yeah, the other thing is that, like, if we were looking at some of the comments that came back from the joint meeting, the joint session, they were like almost in the opposite direction of this. If anything, they were, because this type of having the 10% is the primary imposition that comes from
Okay.
the comprehensive plan.
Fair point.
So they were like going, like, we need to do what we can to like figure out how we're protected from that imposition on free development. So like this would almost go in the opposite direction. To a certain
It's,
I
that's
mean,
a
I'm-
fair point. Again, I'm just,
Yeah,
I
and
don't
think-
want to go backwards when someone comes in to put in 20 houses somewhere out in Towesa.
Right, I think that, you know,
And it's a way, it doesn't have to be in the project. They can contribute in South Kingstown to an affordable housing trust fund. Or they can provide rehab of units in town and make them deed restricted.
right. I mean,
I'd like to take a look at this, you know, and understand exactly what we're talking about. I think we got a little time. So if we can get the South Kingston model, you know, that I'd like to look at it because I'm just not familiar with it. I think that what we have here, that would be in addition to that.
Yes.
Jenny, for sure.
Absolutely.
But I understand what you're talking about and it,
And I'm sensitive to what the town council is saying, what you're saying, that we don't want additional mandates and I.
well, you know, it's
appreciate that.
honestly, as we're having this conversation, I'm thinking that, you know, one of the things that I was sort of hoping we could try to figure out how to do was create a scenario in our zoning that sort of steered developers into certain zones that were more conducive to these type projects than other zones. And I don't know necessarily how to do that, but if we did have some zones that had this, that embraced that type of strategy to them, that might,
And the market
Facilitate
Dominicom
that.
proposal, if I'm correct, makes multifamily high density by right, which would automatically steer people towards that area, developers towards that area, because they have fewer hurdles to go through because it's by right.
right, and it's the form-based code, which would be, you
Right,
know,
right.
looking at as an outgrowth of this. So again, I'm looking for where it may necessarily fit in, but before we put it in,
Yeah.
I want to understand
I
it
was just giving you
first.
another tool to consider.
Yeah,
absolutely. Makes sense.
Um,
All the new ones that we've looked at, none of them have been in there.
I'm sorry, what?
All the new developments that we've seen here in the last few months have not been in the Market to Metacom area.
Right.
No, but I mean, again,
District
you
around
know, market to
Florida.
Metacom, we have to be careful with that. It's a great vision. But, you know, in order for Metacom to work, somebody's got to buy that land.
Right.
You have to have investors come in,
Someone
build
has to be willing
this
to sell the
vision.
land too.
You know, it's a great theoretical Roger Williams University exercise. But the reality of the fact is that, you know, you need to get a tremendous amount of investment and a willingness to accept a long-term return. You know, it's not like a fast turnaround, like it's not like building an apartment building. That said, I think, you know, in theory, I like the idea of saying, you know, how much more can we develop here anyway? You know, in Warren, I think this is one of the fundamentals, and I think the 10%, the one thing that the state's 10% goal. I want to be careful about even giving that legitimacy. Because personally, I don't believe that it's legitimate. I believe that it was a number made up by somebody in statewide planning who was asked to come up with a number and he pulled it out of a hat. And it is unfair at best and criminal at worst to impose a 10% on 39 cities and towns.
So, Mr. Chair, if I could
Sure.
interject for a second before we get to hating the state too much, but what I'd like to offer from what I've heard is that let's have, Allison will be watching this later on. She couldn't be here tonight due to a prior commitment, but she's definitely, that's why we record these meetings. So she'll watch it from that standpoint, but let's have her provide a little bit, collect a little bit of information and provide it, if I don't do that myself, to give it to you folks for consideration. And I'm not necessarily hearing yet a consensus to change the plan with regard to inclusionary zoning, but I think let's collect some more information and then you could decide either at the public hearing that you'll likely schedule tonight for June, and or throw it at you at the May meeting and see if there is something that you want to throw in the
Yeah, I think the
plan before
inclusionary
June.
element could come in
Yep.
May meeting.
So that's one thing. The other is just so you'll know, I just went through it. There is not reference to that in the current draft of the plan in terms of what Jenny's raising.
Right.
So just want to make sure that you're all aware of that.
Okay.
And then thirdly, one of the key component implementation things to this plan, which is also underway, is the housing production plan that we're doing through with Weston and Sampson with funding from Rhode Island Housing. That is a more targeted analysis that will also have some action steps as part of it. And I would say it would be good to see as that report starts to unfold itself in front of you, and there'll be partly a public engagement process as part of that. So I think the specificity of what Jenny's raising can be taken care of as well as part of the housing production plan and what's falling out. And that whole plan, to get at your point with regard to the state, is intended to provide some more solidified information with regard to our existing housing stock, where we currently stand with our housing, is to help to identify what is the gap of need for us. Also with regard to different income levels and different sectors of the population, and grow action steps to help to close that gap. One of which may be inclusionary zoning, and there are other steps from that standpoint. But that's where I would encourage you to throw some of the weight of this discussion at.
Okay, that all makes sense to me. I guess what I would do is I'd just say under work with the town's legislative delegation, Rhode Island General Assembly, to amend the comprehensive permit law too. And then there's the second bullet. It's a paragraph to a greater level. It actually helps move the needle toward helping the state achieve its 10% goal. I'd like to take that out and say, and speak more to raise the percentage of, with the goal of sufficient affordable housing in Warren, as opposed to.
I had that question. Did the whole thing, I mean, this 10% issue,
Yeah,
you know, the goal with the affordable housing is to take care of our own, right?
yes, and
The folks in Warren
again,
that-
it's like,
that have that
we
issue.
may have
But we
more.
don't want to build these things and they will come, right? I mean, we just don't want to build these things and get some of Massachusetts people or.
Well, the problem with this thing is, you know, if you look at 39 cities and towns, we're not all equal, contrary to what Mr. Gablinski put in his article in the Warren Times, where he compared us to Little Compton, which was baffling at best. You know, the number of affordable housing units here compared to Little Compton doesn't even, you know. So yes, in other words, what I think, I'd just like to take out that section. I don't want to give them the satisfaction of seeing their 10% in there, and simply talk about the fact that what we're looking at is building affordable units to the best of our ability within the context of protecting our community. I mean, it's the idea that you simply, you know, that demand is out there and so you have to build to meet the demand doesn't make any sense. There's a limited amount of land. There's a limited amount of space available. And to say we're going to build because people want to move into Warren, it's not logical. And that's something that I think is important. I mean, there's redevelopment, there's all kinds of ways that you can work this thing out, but it doesn't have to, it should not be based on the idea that there's a lot of folks who want houses and, we're gonna build them.
High. I mean. the
I also,
population-
I would also think that when we have the 10% thing in there, what we risk is the teeth of, having language that promotes affordable housing in the event that the state ever comes back and modifies that 10%. So then it would look like, oh, this clause only pertains to an antiquated rule.
For now, you can't avoid the 10% discussion.
Right.
Because the town is as we all know, or at least as I try to educate everybody, the 10% goal is a statewide goal. And the state has siloed each community under mathematical fractions, the equivalent 10%. From my standpoint, we need to step away from that thinking process. Keep the 10% goal as a statewide goal. And then as a collective of municipalities, strive to meet that goal. That may mean that some communities have more affordable housing and others may be less as a function of services or what it may be. But that's part of the purpose of the housing production plan that we've got going, because the idea is to get a better understanding of who we are and our composition and what is the gap that we need to go after. And the idea is to do it under the umbrella of a statewide goal rather than a siloed set of goals that equals 10%.
Okay,
Sorry to interrupt.
No, no,
Mr.
go
Chair.
ahead.
So, but under the comprehensive permit process and your situation under your continuing planning process, because we don't yet meet the 10% goal, however you want to define it, we are held hostage, if you will, to the need to approach that 10%, continue to approach that 10%. Until we get there, we don't have much leg in the game to be able to deal with stuff. So it is important for now to keep talking about the 10%. As we get to that 10%, then we have a little bit more power under our comprehensive permit process, for instance, as it pertains to conformance with the town plan and whether a project should be reduced, say, in number of units or what have you.
Again, I think you could simply then achieve its statewide 10% goal.
Or even like state
just-
required threshold, whatever.
Yeah, I mean, I just want to be aware, I just don't want to get us shoehorned
Meet the
into
current
this,
statewide goals.
accepting the 39 cities and towns. But, otherwise, this was really well done. And I think, with a bit of massaging from Allison, I think we're there. So, could I have a motion to?
So, yeah, sorry. So just wanted to make sure that we give a level of specificity to Allison. I know you already stated it, but I want to make sure that we're clear so she can pick up on it.
Right, so I'll make a motion to accept these edits that Herb proposed with that the state achieve its statewide 10% goal. And that we would look at inclusionary zoning as an element at our May meeting. But in the meantime, she'll rework this to fit into our existing language. We did have good language in the housing element. I think this makes it stronger. So that's the motion. Do you have a second?
Second.
Jenny, you got it. Thank you, Jenny. All in favor?
Aye.
Aye, okay.
Thank you.
I had recommended a few changes to the acknowledgements, the introduction, the forward and the introduction to the comprehensive plan. The reason I did this was because when these were done initially, market to Medicom was viewed as the hub of the plan. And when we brought it to statewide planning, that was the intent. It is a great visionary concept, and it is important to the plan. there was a bit of overstatement in some of the language, and all this does is softens it so that it does not serve as the shining light of the comprehensive plan, which we put together. I mean, that was when it was originally proposed, and this is back quite a while. I don't even know. I think Jim might have been here when we first started doing this work. When that first came out, it was the center of the plan. And since that time, it has been, the plan expanded, and, you know, what we just talked about is a perfect example of it. It's a much more comprehensive plan impacting the entire town, not just the Market to Metacom section. So that's the changes in there are relatively minor, and makes it more of an integral part rather than the shining light, you know, of the plan. So that was the logic behind the changes that I made. I also wanted to give credit to the former Warren Planning Board members. And Matt Atwood and Brett Bobine in particular were very helpful through that process. The rest of us have our names on there. Kate Michaud helped, and obviously former town planner Bob Ruley. That concept development in Market to Metacom is, you know, noteworthy and praiseworthy for sure. So if that works for everybody, I'll make a motion to accept those changes. Third, second, all in favor?
Aye.
Aye, okay. There was another change about the trees, from the forestry folks.
As you may recall, we received an award for some technical, it's a grant, but it's for technical assistance with a contractor of RIDEM. And basically they're helping us to put together an overall, what I would call an urban forest plan. And their technical assistance will be involved with helping DPW, me, as well as the town tree warden and town tree commission to add sort of like best management practices and other things that moves us toward that plan, but also complete streets and green infrastructure. And Molly Hunter, who represents the group providing the technical assistance, has reviewed the draft town plan and made a couple suggestions in terms of how to strengthen the plan. I've gone through at least the draft that she made some copies on, and nothing is too dramatic from that standpoint. There's another paragraph or two in her recommendation that basically just suggests where we can strengthen the plan some more. So I would just suggest that you instruct Allison to make such changes as applicable.
Okay, yeah, I didn't see any problem, and, you know, protecting trees makes sense, and particularly, you know, moving forward, one hopes there'll be a better job done of taking an inventory of the trees that need protecting and acting ahead of the wrecking ball, you know, which is unfortunately the way that building and tree preservation too often takes.
And just again, this is going to be more of a focus on trees that are within town rights of way or on town properties like Burr Hill Park and that sort of thing.
Yep.
It would not be necessarily for trees that are outside of town rights of way, as for instance.
So I'll make a motion to accept those changes and have Allison proceed with those.
Seconded.
Second, Jenny, all in favor?
Aye.
Aye. Other edits? Anything else there, Herb?
1 second, sorry.
Yeah, no worries.
I'm without assistance tonight, so I'm.
Well, what's Ben doing over there?
He's probably answering.
Yeah, I was about to say.
He just read Tony's email that says we need to continue. So I just, Allison sent out an email just, it was either very late last week or over the weekend. So I have a handout for you so I'll give you that. I didn't have time to get it in front of you before the meeting. So just bear with me. It's a 2-pager. And I might suggest you just take a minute to review it, and then that would probably answer your question, Fred.
Oh, yeah, I saw this. Right.
And for the couple things that I have handed out, I'll make sure that they're included as either part of the next meeting packet or somehow attached to the minutes, something like that, so that everyone that's watching will have, in fairness, the opportunity to see what I'm handing out. While you guys are reading, I'll just paraphrase for those that are watching. Essentially, there's several comments, one of which is some changes that are recommended that we're making to the open space map with regard to the specificity to make sure there's a level of accuracy for a couple parcels. At the joint session of the Town Council and the Planning Board on April 8th, there was some issues raised or just a concern raised with regard to affordable housing, which we just talked about at length, and that we've addressed that already tonight. Also, we just, regarding the forestry section with Green Infrastructure Center, that's the technical assistance for the town, so we just made recommendation with regard to that. Also, Fred had written comments, which we addressed with Fred's comments. And then we are still making changes with regard to comments received from statewide planning. For those that we've received by May 1st, there's 3 or 4 sections that we should be getting comment back from this week. So we'll be able to make those. We'll have Allison inflect those changes into the draft before we get to the public hearing that we're hopefully going to schedule tonight for the June meeting. And then again, some more language with regard to farm and forest use in terms of some specific parcels that we're just clarifying for the future land use map.
I don't, that.
And then let me just finish one last
okay,
thing.
sure.
And then lastly, we're still working on some imagery with regard to trying to have the plan have a couple or a few images that are sort of shot from drones or something like that, specific to each of the elements, just to add some, add some flavor to the vanilla.
It's hardly vanilla. I call it rum raisin, frankly.
Yeah. But I just wanted to, for those that are watching, don't have the luxury of a piece of paper in front of them. I just paraphrased the issues that are on that 2-page sheet.
The FFOS and FLUM, can you explain what their issue is?
In so many words, they're basically trying to make a connection between the future land use map and what we do or don't do with regard to updating our zoning regulations. The state's position essentially is that if you're going to make the changes to the future land use map with regard to that, you will have to follow up and make changes to effectively your zoning regulations to accommodate that. And there is statutory language that basically says within a certain period of time of the adoption or the approval of the town plan by the state, we have to make updates to our land use regulations. We'll go that path, whether we meet the deadline or not, it's a different story, but we will do all due diligence to meet the statutory requirements. The concern that, that both Allison and I have is that that as the staff has changed at the state level, so has the position on this. There are approved plans that are out there that basically, I'll couch it as saying that zoning regulations need to implement the plan, but need not be controlled by it. And that's it. And you may know what, Ben may know what I'm talking about from that standpoint. What seems to have changed with regard to the staff up there is that they're making a direct correlation between what your plan, your future land use says, and what your zoning needs to say, and that the two are inextricably linked. What Allison and I believe, which is the prior position of the state, is more along the lines that you will update your zoning regulations to make sure that they're in conformance with the plan, but your zoning regs need not be controlled specifically by your future land use map. And the bottom line there is that your future land use map and your town plan is a general vision. It's the broad-based, broad brush stroke of what you want the town to look like. The specificity of how you get there is in the zoning regulations, the subdivision regulations, and other methods of implementation that you deal with. And that's where you get into the specificity. So it's too difficult to align a broad-based document with specificity from that standpoint. So there's some disagreement at this point between Allison and I with the state. However, the state is the controlling interest here from that standpoint. So we're in the middle of going back and forth with the state in terms of their response. So we don't have the formal letter yet from them that we hope we'll get this week, that we can better have the discussion with them. And Allison, of course, will make the changes as necessary. But there's a concern about the interface and the rigidity of what the state may be requiring us to do with regard to basically acknowledging that somebody's involved in a program. And the way I kind of look at it is that if you're involved in the ag, forest, and open space program, it's a program. And a property owner at any given time can opt not to participate in that program. Clearly within a 5-year period of time or under the year in which they're operating on, and they opt not to, well, there's a penalty for them to do that. But the other side, so it's not something to me that's rigid toward what should be in your zoning regulations.
Mhm.
Again, because it's a program, not something specific to a zoning ordinance. And I don't want to create a zoning ordinance that's specific to a static moment in time with an individual property owner that currently opts to participate in a program that locks them in until such time as we may need to change or
Which is
the zoning.
different, just so that I understand this, that's different from somebody selling their development rights.
Yeah, oh, absolutely.
So if someone has sold their development rights, that's
That's
protected.
deeded,
But
protected.
someone is participating in it, and they would be essentially saying, this can't be R40 anymore because they're participating in this program, but their participation has a beginning and an end.
Correct. We can have a land use plan that says that this is best for commercial industrial and that parcel at the time, and we may even do our zoning that way. And if the property owner at the time opts to participate in that program, as long as they're meeting the requirements of the program, they'll get the benefit from that.
I see.
But it doesn't mean that I don't think that we're required, if they want to do any development, they've got to get out of the program and meet the zoning, what it is from that standpoint. And the converse is true to that as well.
Also, their participation in the program is not contingent either on the zoning or to any particular extent the land itself.
Correct.
I mean, if they have to farm, if they use the farming designation, but if they can get the discount under open space, and it can be crap land. So, or it could be prime developable land. It just, so there's not much correlation between land use and the
Correct.
Use
And
of
I,
that,
and I
yeah.
think we're generally talking about semantics and logistics here more than anything else. But
it's-
again, the difference between a program versus what you're locking into your regulations are two different things.
It also seems that somewhere in the background, there's a fear that if, or an implication, I don't know whether it's a fear, but an implication that if we have something in the future land use plan and we don't end up implementing it, someone could come in and say, oh, but that's in the future land use plan, therefore I'm coming in with an application for that.
There is a connection between your future land use thinking and the way that you implement it that has a direct bearing or direct correlation on, for instance, how you behave as an organization in reviewing development as a for instance. And I think that there's a rebuttable presumption that can go into some of that. On the other hand, things can change, things do change. As it pertains to the comprehensive plan specifically, there is law now that says that you have to look at this plan at least annually to decide whether there's change. So in that particular instance, Jenny, if someone is coming forward and saying that, you should be looking at it on an annual basis to say, have we heard anything, or is there anything out there that is making us change our way of thinking in terms of what our vision is, and at least for the municipal plan.
Great, thank you. That clarified it. I think that's it then for the,
Can I ask one very small question, I hope?
sure.
Sorry, again, I know I'm a late player at this, so there's reference to the seaside sparrow in here as an example of an endangered species. There's a lot of work being done on the salt marsh sparrow, which is a very closely related species here in town on land trust property. Was there a reason why the seaside sparrow was called out rather than the salt marsh sparrow? Do you know?
What are you referring to?
I can, so give me a second.
Is this,
Seaside.
it's not in the stuff that we've got here?
Not
No,
no,
this
it's
is,
Oh,
not
okay.
this
All right.
is,
Yeah, no problem.
What is your
It's on
favorite
page
bird?
4.
Or-
Page 40, this is under, because I'm
Is
on
that
a
a
land trust.
northeast flying sparrow or, sorry. Anybody that knows Monty Python knows what I'm talking about.
Yeah, I do. Absolutely. But the reason why I call it out is because the land trust is investing actually a lot of effort in the protection of the salt marsh sparrow at Hale Farm Preserve and Jacobs Point, both of which are noted in here. And I just was confused because I had actually never heard of any work being done on the seaside sparrow in Warren.
I believe that information was collected from Allison as her connectivity with RIDEM from that standpoint, but since you said the particular species that's being looked at, I think that'd be awesome to add into.
And in
into
fact,
the-
the mural that's just around the corner on the storefront is a salt marsh sparrow, not a seaside sparrow.
I would put that
Okay.
in I've run into this before too. In this plan, we've talked about native species and they left out a whole slew of them
Okay.
initially. So I've put them back in.
Okay,
So I would put it in writing
Okay.
and send it to Allison. And yeah, it definitely should be
I'll send
included
it.
because DEM doesn't, they had some in
and
there.
that's fine. I was wondering
Yeah,
whether
no,
I
sure.
missed something about some other project that's going on in
Absolutely.
town, but
Yep.
No, great.
Good point. Okay, so that then we're in good shape for the comprehensive plan final edits. We would like to have that brought before the public on at our June 24th meeting. The reason for that is that we're required by law to do a number of postings and that involves the newspaper. So as much as we would like to do it tomorrow, or the next week, given how quickly Allison can work, we can't do that. So, June 24th would be the, earliest that we could do it. So can I have a motion to post the, comprehensive plan for a public hearing on Monday, June 24th?
so moved.
Second, Tyler, all in favor?
Aye.
Aye. Okay, so there we go. Any public comment? Seeing none, I'll move along. Before we get to the director's report, I'd like to briefly note there is a development in off Chase Road. It's called the Waterview Developments, the Twisted Homeowners Association. And we have received a number of concerns from neighbors going back 3 years or 4 years about the destruction of a buffer zone that was considered part of the planning board's approval of that development of, I think it's 14 houses, something in that range. The approval was based on a buffer zone that would protect the Audubon immediately adjacent to it, and equally important, the neighborhood that is down topographically from where this development was built. In the process of putting in the houses, the people who have moved in there have clear cut the land. Clear cut it to the Audubon wall, in some cases have knocked down parts of the wall. We have a letter from Audubon protesting this and asking the town to take action.
Was
I
the
mean-
developer supposed to put markers up for the edge of the boundary?
Well, again, I think I'll get to where we're gonna go with this, but the other problem is that water has cascaded down into some of the adjacent houses. These were houses that have been there for a long time. And as a result of not having a buffer there, and as a consequence, their lawns are flooded. In one case, it looks like the septic system is flooded, given the amount of runoff. This was a farm field at one point. CRMC is tangentially involved because of the proximity to the Kickamuit. But it's the issues there are a direct result of a violation of an agreement by the planning board. The planning board made the agreement with GRF Associates, which owned the land initially. They agreed to those conditions, sold that land and sold those conditions to the Twisted Homeowners Association. And at this point, Herb is aware of it, Brian Sullivan is aware of it. And Herb will be working with the building inspector to enforce the regulations for those buffer zones, or, essentially to protect those houses that are down below, and also to protect the Audubon from this incursion by these folks who live there. CRMC did issue 2 notices of violation, but it's something of a paper tiger because they were unwilling to do anything further than just issue the violations. So Herb has the decision that was made. Were you here for that, Jim, when we did the water view?
I know we talked about.
Yeah, it's anyway, yeah, it may have been even further back than that, but anyway, so we'll send you the decision and so that you're aware of it. But essentially the most important thing is just moving forward the town on enforcing the existing approval. And it's important to us, and this is one of the lessons that I've learned through this process, is we have to be very specific and leave no stone unturned when we make these kinds of decisions.
Do we know whether the deeds that transferred, for instance, the lots to the ultimate homeowners, and then those subsequent deeds reference those buffers in the deeds?
My understanding is that the Twisted Homeowners Association, which all of those people have to belong to, has that within it. And
People don't read those, they read their deeds.
again, ignorance is no excuse for, it's like, I
No,
didn't see the
I
red light.
understand.
And in fact, some folks have kept the buffers, but there are other folks who have said, I don't care. And those are the kind of folks that, given the amount of time we spend here, trying to do the right thing for the town. That's the kind of behavior that
Yep.
is, worthy of a slap on the wrist at the very least, but more so ensuring that the terms of the planning board's conditions are met. That's why we're here. We're here to protect the community. And so, kudos to Herb, who's moving forward with it, to Brian Sullivan, who paid attention to it, and to our building inspector.
So what teeth do you have on that?
Well, essentially what's happened is that to answer Jenny's question first, it's written in the homeowners association condominium docs that are
Okay.
not only are they in the land records, but each property owner, when they go through a purchase of a property, gets that information. And it's also included on the final plans that were approved and recorded in the land records. The two different things that are affected essentially are lack of adherence to a 200-foot setback by CRMC for a freshwater pond. And then also for almost every single parcel, a boundary of landscape encroachment. In other words, everything outside of that boundary needs to be left in its natural state. So basically, people have gone in and mowed stuff out. So and then in answer to Terry's question, it's working with the zoning enforcement officer to adhere. So to basically pull out, these are the things that were infringed upon. The most likely what we'll have to do is make sure that they essentially leave the areas alone now. There may not be anything that we can do to, replant, if you will, things, but at least they have to be left in their natural state, let it come back to its natural state. Make sure and probably do some on-field. One of my suggestions was possibly to require the association to bring their engineer back online to demarc the areas, so that there is something that's out there for each of the properties to know the extent of where they can mow and landscape and all that. And then and I don't know if there's anything else that Ben's aware of, but if there's something specifically that needs to be replaced or whatever, we can probably do that.
Would they be, I mean, if it's left alone, then a whole bunch of things are going to come in that are undesirables, like tree of heaven and stuff like
Right.
that.
Yeah.
I would rather that there was an active plan to bring back native plants in a managed fashion so that they don't get outcompeted by invasives that are damaging, like autumn olive and
Yeah,
purple leaf.
the first step is going to be getting notice out to folks. I'm sure, well, I've got to chat with Matt from that standpoint, and Ben may get involved with this in terms of what may be the proper way to deal with this. But essentially, it's at least getting Matt involved, probably getting the property owners in the know, because I'm sure there's some property owners that don't know or were not informed when they, through a title search or whatever of what happened. So getting them informed on certain things with the idea of stopping anything further from this standpoint. And then that third phase would be, is there anything else that needs to be accomplished? Like you're talking about a proactive management plan for the recovery of the property.
And what about the flooded lawns?
Basically the work, engineering was done according to the plans, such as the stormwater detention basin. From that standpoint, the idea of having some of those areas undisturbed was for plant community to sort of suck up the stuff from that standpoint. So the idea is to have it go back toward that way, but the human-made infrastructure is there the way that it was permitted. If there's something that pops up as part of this review process that shows otherwise, we'll have to address that as we see fit. For instance, reviewing what the 2 violations were from CRMC and seeing if there's any teeth that can be hung there. Again, that's going to be, I think that part of the area is already wet and that some of the issues were already existing. Whether the development in the way that it has been addressed inappropriately or otherwise, whether that has exacerbated an existing adjacent properties situation. I can't offer
has been a
information at that point,
particularly
but the
wet
idea
year.
is to, at least for the stuff that was supposed to be done, get it into the state that it's supposed to be in. And if that helps address those particular issues, great. If it doesn't, it's probably related to a pre-existing.
It's been a very wet year.
Yeah,
And it would be a
absolutely.
really
The water
bad
table
year
side,
to be
right,
able to
yes.
determine what was existing.
Yeah, and
and what
again, you know, it's
caused.
anecdotally, one of the neighbors said, you know, I didn't have this water before the house was built. So, you know, and they've got pictures of it. But again, as
Yeah,
Herb
that
said,
wet
I think
year.
that the most important thing is to meet the conditions that we establish. I mean, it's
That's all
like,
you can do.
and there has been, you know, some arrogant pushback. So, you know, that's,
As you say, ignorance is not an excuse.
yeah, so I think, you know, you've got to see if this helps, you know, that was certainly our intent. And at the very least for the Audubon as well. I mean, it's a wildlife refuge, you know. The concept there was, you know, to provide some kind of a buffer as opposed to, you know, having the volleyball net, you know. maybe-
Dog barking at the.
Sort of worst case recourse is that it may end up, there may be something that has to go to housing court. My brain is not used to dealing with that type of a situation from where I come from, but that is something that the town has used frequently to help in enforcing its.
Hopefully it won't come to that. You know,
Right.
you know, our goal is to, you know, have people do the right thing, you know, maybe they need, you know, a swift kick in the pants to get there, but if not, we've got that. Okay, so that's that part. The director's report. Herb?
It took me a while to do that one. I forgot to do it last month, so to speak, and I promised I'd do it. So I usually try to hold up to my promises. So you got 2 months worth of reports. If you have particular questions, feel free to ask me, but essentially I think you can see that things remain busy in my office. I know just from a couple highlights, you can see I've been heavily involved in grant related stuff. For you, in terms of your purposes, obviously, we're dealing with a comprehensive plan. After we deal with the comprehensive plan, we'll have the housing production plan as well as update to the land use regulations. And then development applications that are out there. I believe your May meeting is going to be very healthy in terms of the agenda. You already know that you've continued Liberty Street to that meeting. I suspect that you will have St. Mary of the Bay back in front of you. I suspect you'll have the Comway Properties LLC back in front of you. I know that 75 Crowd Street's working diligently on their preliminary plan.
Can I
And
ask what Conway is proposing?
It's essentially 3 parcels that they're going to collapse into 1 parcel. There's one existing building that's out there now. This is Commercial Way. And they're proposing 2 additional commercial style buildings, of which to house probably at least one of the buildings will house an existing business in town that it's bursting at the seams.
Okay.
This was a plan that was originally presented to us as a different concept.
Oh, okay.
It was the one
Yeah,
that had
okay, now I remember.
a series of buildings
Okay,
that were all
I
going
thought
to
this was
be
a-
service people's
Yeah, no, I was,
days.
I was thinking of
This was the one with
Concierge,
the.
not.
Oh, yeah,
the
yeah,
daycare,
right.
I'm sorry, what?
The daycare.
Yeah, it's
That's one of-
adjacent to
yeah.
the daycare. No.
There are a couple other, there are a couple other properties that, there's some, I use the term loosely, threats of an application here and there.
Is Concierge one of those?
Search is one of those. Yep.
Okay.
So, there's.
Which that?
That's the, across from, East Bay,
Near Sip and Dip.
near Sip and Dip, across from Sip and Dip, it's the office building that's set back from the street.
These built
Which
originally as
Sip
a
and Dip?
church
No.
and then was converted to
Oh.
commercial use.
And 136 or?
On 136.
Yeah, okay.
And
Say
it's just south of,
308 Market, something like that.
yeah, it's just south of the, Soames Meadow Preserve that the Land Trust has.
Um,
So, but nothing's coming forward.
Well,
that.
there are things that I know about, but not yet.
No.
But I'm not gonna
Not
do it.
yet for public consumption, put it that way, yeah. Yeah, the one thing I try to do is hold the confidence of some people that I speak to, because that way, I can usually have a more honest conversation.
They can get things worked out
Yep.
smartly.
Great. Again, I want to commend, our fearless leader, Herb, for the work that he does on a regular basis. I talk to Herb at least twice a week, if not more. And it's been incredibly helpful in terms of my understanding, and also in terms of presenting the information to the rest of the planning board.
Well, and I want to say I'm impressed with all the grant work that you're getting done. That is obviously hugely important in any given time, but particularly now. And I just think it's tremendous that you're able to get that accomplished. Thank you.
Thank you.
And we're encouraging the town to give them a salary increase as soon as the $13 million is paid off. Okay, I think that's it. Yes?
As far as I'm aware, yes.
Great.
Unless there's something else on the agenda that's not sitting in front of me. So, yeah.
Great. How likely is it that Liberty Street will come before us? Is that still?
I wouldn't speak about it.
Okay, so we don't,
Yeah.
in other words, we don't have any idea whether it will happen or it won't. Okay,
There, one thing I didn't say, which is part of it, is there was an appeal filed of the master plan on just this past Friday afternoon.
okay.
So there is at least some pending proceedings that will occur at Superior Court.
All right. And under the advice of counsel, we will not say another thing about that. I have a motion to adjourn.
So moved.
And all in favor?
Hold on a second.
Oh, I'm sorry.
I'm sorry, I was wondering if there was any information about the Penny Lane project?
Nothing as of now. I mean, other than the next step, I'm assuming would be the preliminary.
Right, so the question, in case it wasn't heard, was just if there's an update on the Penny Lane application process.
I'm sorry, I was under the impression that it was on the agenda tonight.
Oh, no.
No, originally we had Liberty Street there, and that was continued. Penny Lane, the written decision was just produced, signed, and recorded last week. So we're in the appellate stage for that, for the master plan. And I already know that Frank Spinella and his team are preparing the preliminary plan application. Is that?
So as far as we know.
Yeah, no, I haven't, I wanted to see if.
Can
I
you
could
come up to the
provide-
microphone,
I'm sorry.
please?
Yeah. I just wanted to see if I could request. a
And name and
proposal.
address.
Sorry, it's 25 Colonial Drive.
Sorry.
I'm in a butter to Penny Lane.
Yeah.
And I wanted to see if I could propose or request like a green fence or a living fence around the perimeter.
Again, I think that would be something that we would, I hear what you're saying.
Right.
And that is, as you just saw with this thing in Waterview, it is something that we've looked at. So, we would certainly entertain that and,
Right, so
my-
any particular comments or suggestions that you have, you're welcome to email, not tonight, but to,
No, I know my wife has been in contact with
Okay.
you quite a bit.
yep, but to,
But I would put it in writing in
Right.
that way and be prior to, that way it'll go out to all of the members of the planning board. I would do it in advance of the meeting.
because technically we don't have, even though that whole application is pending from that standpoint, we don't have a preliminary plan application before us to review at this point. So the particular comment that you're making is applicable once we receive that. But in the interim, you're welcome to submit anything to me and I'll get it to the planning board members at the appropriate time.
Okay.
One question for you, Herb, and for him is typically when you get that information, how much notice would he have for looking on the agenda? to
So
to
for
see?
instance, if tonight's meeting, if we were talking about it tonight, I would love to get that letter no later than the Wednesday before the meeting so I can get it in the packet. But you are during the public hearing process, you are welcome to submit comment and information to them for their review.
Yeah, I just think it's even better if you get it in
Yeah.
earlier.
Right.
Yeah, because the absorption on their part is much better if it's in the packet than during the course of the evening.
How would be the most effective way for me to find out the date of that next?
Stay in touch with me.
Yeah,
Yeah. So if you give me a call or shoot me an email with your question, I'll be happy to.
All right, I did actually prepare a letter.
Okay.
If I needed to hand it out tonight, but I can make some
for sure.
additions or revisions to it.
Okay. Sure.
Absolutely.
I appreciate it.
Thank you. Okay, motion to adjourn and we adjourn. Here we go.
Who did that? Sorry, so I.
Karen,
Pick some.
Karen, I did.
Terry made the motion. Tyler seconded it.
Yes.
All in favor?
Aye.
Whatever.
Didn't even need the extra boost.
That's right.
Thanks, Tyler.
That's-
Thank you, Jim. I went by your hacienda today on my kayak.
Yeah, now what color cap? You usually wear standard color cap?
I was wearing my headphones. Blue kayak.